Good morning. I'm glad to see that you all came back. I noticed yesterday that as almost every speaker got up, they mentioned how happy they were to be here. When I arrived yesterday and walked into the auditorium, I walked up to David and I said, "David, how happy I am to be here." And David looked at me and he said, "At your age, you should be happy to be any place." And I said, "I came over 9,000 miles for that reception." And then I started to think after I sat here yesterday and listened to all of the presentations about the purposes and how business reorganization works, where did a keynote speech, an introductory keynote speech, fit into what was going on? And what would I talk about tomorrow? And I concluded that maybe Robert Burns was right when he said that keynote speeches are challenging and that the best keynote speech should have a cheery opening, a bright conclusion, and not much in between. I'm going to take a slightly deviant position and take a Dickensian role. I will be the voice of the past and perhaps a little bit of the present and maybe some of the future, but not with the accuracy of the forecasting that's done by economists and financial advisors who, after all, predicted 9 of the last 4 recessions. Yesterday, we heard various submissions on bankruptcy, restructuring, and reorganization, and the means to deal with financial distress, particularly of commercial enterprises. My focus will be on the development and evolution of bankruptcy reorganization in the United States. And in that connection, what is a corporate reorganization? It was described by Thurman Arnold, a distinguished public servant and an assistant attorney general in 1937, in the midst of the Great Depression, as a combination of a municipal election, a historical pageant, an anti-vice crusade, a graduate school seminar, a judicial proceeding, and a series of horse trades, all rolled into one thoroughly budded with learning and frosted with distinguished names. Here, the union of law and economics is celebrated by one of the wildest orgies in intellectual history. Men work all night preparing endless documentation in answer to other endless documentation, which other men read in order to make solemn pronouncements. My guess is that it was the concept of an orgy that attracted the bevy of professionals you saw yesterday. In 1935, Professor Charles Warren of the Harvard Law School, in his book, Bankruptcy in United States History, observed, "Bankruptcy is a gloomy and depressing subject, a dry and discouraging topic." And I thought about that comment last night, and I remember when I first started teaching at NYU, after a few years, they decided to do bottom-to-top evaluations. And the students were asked to fill out evaluation forms each semester. In those days, before computers, it was all done on paper. And after the university tabulated all the results, they would send you the forms. And I got my forms, and I started looking over the forms. And I came across this form, and the student had written, "Professor Miller, if I had 1 hour to live, I would want to spend that hour in your class." I was impressed. I thought that was pretty good. So I took it home, and I gave it to my wife, and she read it carefully. And she looked up and she said, "Did you read the back of the page?" And I said, "No, what does it say?" It says, "It would seem like an eternity." So you are forewarned. Taking those observations into consideration, how did bankruptcy reorganization evolve to become a major practice area and one of great public interest? Integral to that answer is, the answer to that question is the status of debt. If we were asked who made the discovery which has the most deeply affected the fortunes of the human race, after full consideration, we might say the discovery that debt is a saleable commodity. At the entrance to the office of Moody's in New York, inscribed in a stone over the entrance, is the sentiment that credit is the foundation of capitalism, and that credit is dependent upon confidence, and that once confidence erodes, failure occurs. And when that failure occurs, you need to have an escape valve, some way to deal with that failure. Colonel Borman, who at one time was the CEO of Eastern Airlines, made the comment during negotiations that capitalism without bankruptcy is like Christianity without hell. So, with that observation, debt intrudes the substantive and procedural process of bankruptcy that is intended to resolve claims to the assets of a debtor that is unable to satisfy all of its legitimate obligations. The underlying principles that permeate bankruptcy, American bankruptcy philosophy, are: one, a fresh start for debtors, initially for individuals, but clearly there is the theory that a corporation is a person, and a corporation is entitled to a fresh start. Two, equality of distribution to creditors having the same legal rights. And three, economy of administration. It is from these three basic principles that bankruptcy law in the United States moved into its expanded role of providing for the rescue and rehabilitation of distressed commercial enterprises. It is an offshoot from basic bankruptcy, and today it is seasoned with a great array of professionals, investors, secured and unsecured creditors, distressed debt traders, hedge funds, equity funds, corporate raiders, legal innovations and challenges, as well as a manifested public interest, sometimes furthered by governmental intervention. The development of bankruptcy reorganization law illustrates the ever-changing process that is propelled by economic cycles and tempered by political and socioeconomic objectives. It is also fueled by a basic human motivation: greed. Although the founding fathers of the United States had sensitivity to bankruptcy, and the United States is unique in this area, that the Constitution actually provides that Congress is invested with the power to pass uniform laws on the subject of bankruptcies. Despite that power, during the 19th century, for large portions of the 19th century, the United States had no bankruptcy law. The federal government was basically distrusted. Federal courthouses were distant from the people. So 3 bankruptcy acts that were passed during that century had very short lives. But what they demonstrated was bankruptcy laws were only enacted in response to a financial catastrophe. And generally, at least in the beginning, they were for limited periods of time, and they were generally directed, for the most part, to individuals. So what happened? I'm here today because I'm the last living expert on the Act of 1898. So I'm going to talk about the Act of 1898. In 1898, as a result of the severe financial crisis and recession of 1893, Congress recognized the need for a national bankruptcy law, and it enacted the Bankruptcy Act of 1898. The act, as originally intended or enacted, did not provide for reorganization, but did introduce the concept of referees in bankruptcy being responsible for administrative and judicial functions under the Act. The 1898 Act remained in effect until 1978, when it was replaced by the Bankruptcy Code and under the Bankruptcy Reform Act. It had no provisions for reorganization. So how did reorganization get into our bankruptcy law? Well, in your own minds, you have to picture the Great Depression of the 1930s. The Depression occurred, and what was happening? Factories were closing all over the United States. The unemployment rate was zoomed up to over 25%. Men were standing on the street corners in downtown Manhattan selling apples. There was great concern as to where the nation was going. What could you do with these companies who had closed their factories or were in the process of closing their factories, eliminating jobs all over the place? Well, a bunch of professionals, academics got together and they said there must be a solution. And what they began to think about was what happened in the 19th century in connection with railroads. After the Civil War, everybody wanted to build a railroad that spanned the continent. And very much like creating computer networks, access to credit was free, and everybody wanted to own a railroad that went across the country. And somebody, they didn't have computers in those days, they probably used an abacus, prepared projections that if you build it, they will come. And nobody took into account that everybody wanted to build a railroad. So instead of one railroad, we got the Union Pacific, the Southern Pacific, the Central Pacific, and the Northern Pacific. And they were all built on a timetable. And they all sold bonds. And the bonds were premised upon the fact that when we get the railroad operating, there will be enough revenue to service the bonds and the other liabilities. Well, anybody who's been involved in a developmental company knows that the projections never work out. You never build on time. You don't anticipate all of the problems that you're going to have in building out the railroad, and that's exactly what happened. And each one of these railroads, essentially, began to fail. And there was, a lot of these railroads were subsidized in the context that right-of-way was given by the federal government. Now, what do you do with a railroad that cannot service its debt, that crosses state lines? Well, if you're a judgment creditor, if you're owed money and you get a judgment, you can execute on that judgment. Well, what can you execute on? The judgment creditor in Missouri with the Northern Pacific goes out and gets the sheriff and goes to execute on the judgment. He executes on 6 feet of track. What is 6 feet of track worth when you try to sell it? Basically nothing. So the concept was, how do we retain value with all of these railroads that are failing? And how do we fulfill the public interest in having railroads, which was the only real mode of transportation across vast areas of the United States? And somebody came up with the idea of an equity receivership, a receivership which was started with what we called a creditor's bill. And in the federal district court, and have the federal district judge appoint a receiver and authorize that receiver to operate the business. The problem was the railroad crossed state lines. So how are we going to deal with that? So in every state, every federal district that the railroad ran through, a receiver was appointed. And the deal was the same receiver, so that you ended up with a receiver running the railroad. And there was a stay issued against creditors. And the objective here was to preserve value, that by keeping the railroad running, you would increase the value, the going concern value of the railroad. You would complete the railroad would become successful, and you would keep the jobs. This concept of preserving going value permeates business reorganization. And as equity receiverships became popular, finally they ignored the state lines, they ignored different districts. It became sort of a collusive process where the debtor would agree to consent to the appointment of a receiver. The receiver would take off, run the railroad, protective committees were organized, and that was the beginning of what became the reorganization paradigm. It served the public interest, but most importantly, it preserved going concern value. And what happened during this period of railroad reorganizations? Ultimately, rules began to come out, decisions began to come out as to how these equity receiverships, these railroad reorganizations, would operate. And as the Supreme Court began to deal with the problems that arose, we got the absolute priority rule, which said basically, junior creditors don't receive any consideration until senior creditors are taken care of, and equity holders don't receive anything until all creditors are satisfied in full with interest. Notice due process issues came up in railroad reorganizations, and the Supreme Court said there has to be due process. There has to be notice. People have to have an opportunity to be heard about reorganization. These railroad reorganizations, some of which went on for many, many years, were very, very successful. And when the Great Depression occurred, this is what the academics and the professionals looked to deal with the issues around the Great Depression. How are we going to rehabilitate and resuscitate these industries that were dying because of the Great Depression? And in 1933, the Congress responded, and emergency legislation was passed to bring into the bankruptcy law the concept of reorganization. And it was all based on the railroad paradigm, the reorganization paradigm of railroads. The thrust of it was we have to preserve jobs, we have to preserve going concern values, because if we don't have these statutes, these assets will be liquidated for minimal prices. And resuscitation and rehabilitation of businesses is a virtue. And the Supreme Court, and courts don't sit in vacuums, the Supreme Court was aware of what was going on, and it recognized that you would have to hold secured creditors at bay for some period of time. And in many cases, in 1935, 1937, the Supreme Court said it is constitutional to stay secured creditors from the exercise of remedial rights. So the seeds were all planted. And in 1938, Congress passed the Chandler Act. And it was the Chandler Act that people referred to yesterday, which established the business reorganization chapters. And for reasons that were pertinent at the time, there was Chapter 10. Chapter 10 was corporate reorganization. It was largely drafted under the direction of William Douglas, who later became a Supreme Court justice, who was very leery of what had happened in railroad reorganizations and wanted a very comprehensive statute in which the SEC was a major party in interest. It was a statute that required the appointment of one or more reorganization trustees who were objective and disinterested. And then there was a lot of sentiment for the small, what was referred to yesterday as the mom and pop businesses. These were businesses that were unable to pay their unsecured debt, that needed to make what was then called arrangements with their unsecured creditors. And these were the two basic business reorganization provisions. And both of those provisions required the application of the absolute priority rule. Chapter 10 required mandatory trustees, unless the liabilities were less than $250,000. And Chapter 11 had the concept of the debtor-in-possession. But we spoke yesterday about the debtor-in-possession as if it was a universal situation. It wasn't, because under Chapter 11, even for mom and pops, the court had the authority to appoint a receiver or receivers. And the general theme in the United States was in Chapter 11, there was a receiver or receivers. So that if you were practicing in the Southern District of New York and you were in Manhattan, You could file a Chapter 11 under the Chandler Act, and you would get a debtor in possession. If you crossed the Hudson River and went to New Jersey and you filed a Chapter 11, you got one or more receivers. If you crossed the East River and you went to Queens or Brooklyn, you got a receiver or a number of receivers. So it wasn't a universal, the debtor in possession. And the problem under the Chandler Act provisions was that Chapter 10 was complex. The appointment of the mandatory trustees was not particularly inviting to management. When you went to a board of directors and said you have a real problem here, you need to go into bankruptcy. And because you're a public corporation and you're a complex commercial enterprise, Chapter 10 is what you should do. The board and management would say, well, what happens to us? And you would say, well, you're out. The trustee will supersede you and probably change management. Well, that wasn't very inviting. So Chapter 10 became unpopular. The number of Chapter 10 filings were always very minimal compared to Chapter 11. So here we were moving into the post-World War II world. Credit was becoming accessible. The public was beginning to invest in the stock market. The concept of going public was grabbing the whole of the business world. And it was an unusual situation because Wall Street broker-dealers wanted to take companies public. And I remember being at meetings where the so-called underwriter would say, if you can give me a company that has $1 million of volume, I could take that company public. I don't care whether it's profitable or not. It's volume that counts. And in New York, we had a lot of garment center firms that if they had a really good number that year would get $1 million in volume. So in the 1960s, going public became the rage. Credit was opening up. You began to see banks lending money to startup companies, companies that had been in existence and needed capital. Well, inevitably an economic cycle changes, or the next season you don't have a good season and you can't service the debt. So the issue became, how do you deal with these companies when you looked at Chapter 11, and Chapter 11 XI was adopted to deal with unsecured debt. You could not affect the rights of secured creditors. You could not affect equity holders. All you could do is deal with unsecured debt. Well, it wasn't satisfactory. And Chapter 10 wasn't satisfactory because of its structure. So what happened? The way reorganization becomes important is through innovation. We had all these companies. They needed relief. And the objective of the Chandler Act was to give distressed companies a reasonable opportunity to determine whether they were reorganizable, to allow them the time to look at the assets and the liabilities and the structure of the business. How could we get these companies into Chapter 11? That was the challenge that I faced and my colleagues faced. How could we use Chapter 11? And we premised everything on the objectives that were announced under the Chandler Act, that rehabilitation is good. Rehabilitation is a virtue. It is better than liquidation. It preserves going concern value and it preserves jobs. And what's important to all of these innovations is a compassionate court, a court that is aware of the situation and aware that a bankruptcy statute, a bankruptcy law, is a socioeconomic piece of legislation, that it has objectives. And the question is, how do you implement those objectives? And as the Supreme Court said, you cannot read the words of the statute with the ease of a computer. And the Second Circuit said the worst way of interpreting a statute is to read the literal words. So what we emphasized is that within the concept of Chapter 11, you could have these reorganizations, these innovations. Now, not everybody agreed. As somebody mentioned yesterday, the SEC fought us tooth and nail in connection with that. But there was this constant strain between Chapter 10 and Chapter 11. And that was the primary litigation. But the concept of Chapter 11 was there's a creditors committee. It wasn't called an official committee in those days. There was a creditors committee, there was a debtor, there was an exchange of information, and the bankruptcy court was accessible. What made it functionable was the fact that the bankruptcy court was always there. And the bankruptcy court was an expedient court. You could go to the bankruptcy court at any time and say, we have a problem, and a referee in bankruptcy, or later a bankruptcy judge, would give you a hearing. They sometimes refer to it as summary proceedings. And you would get a decision very quickly. So what we did is we transformed Chapter Roman 11 into the main reorganization vehicle. And when we got into the 70s, as credit expanded and more failures were occurring, it became the mode of restructuring and reorganization on the premise that rehabilitation, resuscitation of a company is better than liquidation, because if you liquidate these assets, they will yield nothing. And something very important happened. Congress repealed the absolute priority provision in Chapter 11. So that now in Chapter 11, you could negotiate with the creditors committee, you could make arrangements for junior creditors to participate, you could provide for equity to participate with consent. And there was one other element. The debtor-in-possession, or the receiver in Chapter 11, had exclusivity to propose a plan forever. And that was leverage. And leverage is important in bankruptcy reorganizations. And debtors took the position, if you don't agree to a plan with me, I'll just liquidate the company, and you'll get nothing. Well, that was a great force in those days. Well, reorganization expanded in the 70s, and in 1975, W.T. Grant, a major retail chain, filed a Chapter 11 petition. It was the first billion-dollar case. It was the only debtor case that was ever filed by Wachtell Lipton. Leonard Rosen, who was the partner in charge, after suffering through the W.T. Grant case, said, Wachtell will never file another case under Chapter 11. And they have maintained that ever since. He aged 25 years in that case, but it's okay. This expansion of using Chapter 11 coincided with the fact that a National Commission on the Bankruptcy Laws had been appointed by Congress to investigate and determine whether the bankruptcy laws should be amended, reformed, or repealed. The 1970 Act was the result of about 10 years of negotiations and study. It wasn't something that occurred just like that. And in the reorganization portions of the 78 Act, it adopted the best parts of Chapter 10 and the best parts of Chapter 11. And its underlying motivation and philosophy, again, was reorganization is good. It's good for the country. It's good for the creditors. It's good for the investors. The objective here is to preserve going concern values. Rehabilitation was the theme of the 78 Act. And in that connection, the code, as it became effective in 1979, gave protections to debtors that did not exist before. The automatic stay, which had been in the rules, now became part of the statute, and the absolute priority rule was relaxed. And on top of that, for the first time, you had provisions in the law about financing the operations of a debtor. Not only financing, but giving the lender the highest super-duper priority that could be given. And one of the objectives of the 78 Code was to induce debtors to institute reorganization proceedings before it was too late. Don't wait until there's nothing left to reorganize. Start the process while you have assets that are unencumbered, while you have cash or whatever it might be while you can get financing. And the code provided that you would have a reasonable period of time to pursue reorganization. And the concept was that there would be a creditors committee, and essentially the negotiations would be between the debtor and the creditors committee. And the code adopted the debtor-in-possession principle. That made it official. And why was the debtor-in-possession principle adopted? Because we did a study, and we found out that receivers and trustees were inept, that they were generally lawyers. Lawyers did not know how to run these businesses. It was a patronage tool. It did nothing to satisfy the main objectives of reorganization. And we had the example that in the Southern District of New York, where the debtor-in-possession principle was in effect, there were many, many reorganizations or arrangements, as they called it in that day. And one of the philosophies of the code was, we want to have a consensual plan. Consent was an underlying provision of the code. And it was intended that most of that would occur outside of the courtroom, that the bankruptcy judges would only see a tip of the case, and that rest of the case was really these negotiations. And that's the way we proceeded. We tried to get consent in all these cases. We tried to use the objectives of rehabilitation and reorganization and preservation of going concern value. So that was the principle that came out of the '78 code. And it seemed to be working. However, as we went on over a few years, another principle began to emerge, and that was the principle of maximization of recoveries to creditors. Not a bad principle, but it was a principle that was sometimes in conflict with the concept of rehabilitation. And it created concerns about what is the right road to travel to reorganize a company. And as credit expanded, more parties became involved in these Chapter 11 cases. And the way Chapter 11 was being administered changed because the world changed. Back when it was in 1978, it was relatively simple. You could actually tell what the financial condition of a business was by reading the balance sheets. Financial manipulation of balance sheets had not yet occurred. Off-balance sheet items was not really that prevalent. Valuation was a simpler process. Well, as the maximization of credit recoveries became a theme, in some ways it subsumed the concept of rehabilitation and restoring the company and sending it back into the economy as a viable organization. The world changed on us. The way business was conducted changed. Chapter 11 initially was founded on relationships. Relationships with your bank lender, relationships with your vendors, relationship with your investors. That began to change as we moved into a more complicated world. Relationships started to change. The way credit was extended started to change. The 1978 code was directed to dealing with businesses that essentially finance themselves with unsecured credit. As we moved to the end of the 20th century, that really changed. All financing, with very few exceptions today, is secured financing. Secured creditors have a different position than unsecured creditors. And the way financing has developed, all assets, somehow the banks and the commercial lenders finally discovered the Uniform Commercial Code. And they found out it was easy to get a security interest. And everything got liened. Now, in that kind of a context, a reorganization case is difficult because bankruptcy is really not for bankrupts. You can't run a business unless you have financing or cash. And when all of your assets are liened up, you're not going to find a lender. Nobody will lend to a Chapter 11 debtor without getting a first lien. So the consequence is that for debtors, you had to go to your existing lender. And your existing lender held all the cards. And that was a change from what was contemplated in 1978. And relationships changed. Banks no longer had a relationship with a borrower. Banks sold down their claims. They only stayed in for a very small piece of the outstanding debt just to maintain an administrative fee position. And then there emerged the distressed debt traders. And the distressed debt traders are a major change in the world. When the bankruptcy rules were changed in 1991 and made distressed debt trading really free of the court, a whole new industry opened up. And the distressed debt traders had different objectives than reorganization and resuscitation. Some distressed debt traders were interested in a quick profit. They looked at a case and they said there's going to be a reasonably good dividend in this case. And they went to whoever the creditors were and said, I'll buy your claim at a discount. Other distressed debt traders decided this is a good way of getting control of the company. If I can get enough of the claims, I can control the case. And the shadow banking system arose. And the shadow banking system took over from the commercial banks. There were no longer the relationships, and Chapter 11 became somewhat acrimonious. So where are we today? I just want to see what the timing is. Where are we today? What happened? Where are we today? What has happened to reorganization? It's changed dramatically because of the way business is being conducted, because the debt that we're dealing with today is secured debt. So what has happened to the bankruptcy practice? The bankruptcy court has essentially become an auction block, a place where you go to sell companies, sell assets. Reorganization or rehabilitation, in most cases, is not the primary purpose. The purpose is get these cases done, get them out of the court very fast, and depending on the nature of the collateral, liquidate the collateral. So if you go back and you look in the mid-1990s to into the 2000s, there isn't, with any exception, maybe one exception, any retail chain that ends up in bankruptcy is liquidated. Why? Because the financing is not there. The Chapter 11 financier is the old financier. And the Chapter 11 financier will look at the inventory in the retail store and say, I don't see inventory, I see dollars. And a lot of this is the result of the 2005 amendments to the bankruptcy code. So those cases go very quickly. If you cannot get financing, you cannot survive in Chapter 11. And that is the short, unfortunate circumstance. And coupled with that is the reservation that companies have about commencing bankruptcy. Even though the stigma is practically gone, there still is a great reservation about filing a bankruptcy petition from the management, from the board of directors. But I think there are two cases that sort of demonstrate what can happen in Chapter 11. If you go back and you think about the original intent. One is Circuit City. Circuit City was a chain of retail stores which sold electronics, around 1,100 stores, got into great difficulty, had a secured lender. Secured lender had about $2 billion plus of loans outstanding. The company was coming to Christmas. It needed to fill in its inventory. It had to go to the lender to borrow again. It had stores that were unprofitable. The company decided to file a Chapter 11 to take advantage of the assumption and rejection of non-residential executory leases. The company filed in November. The lender agreed to lend through December. The loan had to be repaid the day after Christmas. Well, for a retailer, that's the death knell. So Circuit City actually operated for something like 3 months and was liquidated. Compare that case to American Airlines. Jay spoke about American Airlines yesterday. But American Airlines was successful because it took the advice of its professionals. At the time that American Airlines was having trouble competing, was having trouble with its labor unions, American Airlines had $5 billion in cash. The argument was made, well, you don't have to go into Chapter 11. You've got $5 billion in cash. You could wait until you expend that $5 billion. Well, the board of directors of American said no. And the Chapter 11 petitions were filed, and American had the requisite financing to get through the Chapter 11 process. And what happened? Jay posited that it was all a question of consent, but it was more than consent. It was a classic reorganization. The management of American, even though bitterly criticized by the unions, they were competent. And during the course of the Chapter 11, they restructured the business, and the business began to operate efficiently. And then on top of that was the merger with US Air. And there were a lot of different people involved in that, including ad hoc committees. But even if there hadn't been a merger, which has now gone effective, American would have come out of Chapter 11 with value for stockholders. Now think about that in the context that on the day that American filed its Chapter 11 proceedings in November of 2011, American Airlines stock was 29 cents a share. On the effective date of the plan, for the purposes of the plan, the old equity was valued at $17 per share. That's quite an improvement. It demonstrates what you can do in Chapter 11. There was some value for the merger, but today the American merged airline is probably selling with a value of $30 per share for the old equity. So that was a successful one. When you compare those two cases, you see what's happening. So we are now at a point in history where there's a question about, is the reorganization paradigm still vital? Is it still viable to take a company into Chapter 11 and reorganize it in the context of where we are? And the argument is made, well, the reorganization paradigm, which was intended to preserve going concern value, is no longer viable. Why? Because we are getting going concern values in bankruptcy sales today. That's an interesting argument, and I don't know whether it's valid enough. I know this, that 15 years ago, if you had a liquidation sale in bankruptcy or outside of bankruptcy, very few people showed up. It's true, in bankruptcy today, there is much more active bidding. There's much more interest in acquiring assets or acquiring businesses. Is that going concern value? Well, in some of the cases in which the bankruptcy court has determined it's moving too fast, when you come in with a prearranged deal and a prearranged sale, some of the bankruptcy courts say, wait a minute, you're moving too fast. Maybe there's more value here. And in many of those cases, it turns out there is more value. We've had a few instances in the Southern District of New York where in the first 2 weeks, the court has said, no, slow down, let's see where we're going. And what has happened is more value and more value. So we're in a period of time when we're searching for what should be done. One thing we know is that the world has changed. We can't go back to 1978. We have to come up with a statute or some laws that can deal with secured creditors, that can say remedial rights can be delayed for some reasonable period of time, or may be subordinated, or something can happen to those. Well, we really have to decide, is there a virtue in reorganization? Now, in that context, there are some cases that I'll refer to in just a minute. But all I want to demonstrate to you, and I think my time is running out, David, is that true? Yep. I'll close, and I had a lot more to say, and if you really want to hear about it, well, you can call me back, and I promise you I'll give you a discount off President Clinton's speaking fee. But I want to say something in closing that is very important. It's the bankruptcy court that is a major player in reorganizations. It's the compassion and the understanding of bankruptcy judges, in understanding that it's just not a black and white statute, that there are objectives that have to be attained within the four corners of the bankruptcy law. But the bankruptcy law is subject to interpretation. And that thin black line is often the difference between being run over by secured creditors and being able to reorganize a company. And that's what the American Bankruptcy Institute Reform Commission is all about. What should be done with the bankruptcy laws? And if you think that the bankruptcy court is only a place for sales, and that the most important thing is to get these companies out, and bear in mind, American Airlines was in Chapter 11 for over 2 years. That's more than the 18 months of exclusivity under the bankruptcy code. Classic reorganizations take time. No company files a bankruptcy petition because they're doing well. You file a bankruptcy petition because you're having problems. And it takes time to change those conditions around to get to a resuscitated business. So I admire bankruptcy judges who understand the objectives and take that into account. Now, I want to say something about the Southern District of New York. The Southern District of New York has incurred some terrible things recently. A little bit more than a year ago, I guess it was, Arthur Gonzalez decided, shortly after becoming the chief judge, to voluntarily retire. And though Arthur may be small in stature, he is a giant at the law, and he is sorely missed. And as Judge Gonzalez mentioned on the first day, a little bit over a week ago, we lost Judge Lifland. And he was an icon for all the reasons that were expressed. And approximately 10 days from now, Judge James M. Peck is going to fold up his robes and return to the world of ordinary mortals. He will be very sorely missed. And if you really want to understand how reorganization works, I suggest to you that you do a little investigation into a case called Charter Communications, a case that was administered under Judge Peck's supervision. An extremely complex case. And if you want to see innovation and imagination used in the restructuring process, you will look at this case and see the problems in this case about maintaining viability, maintaining tax attributes, and dealing with things that were never contemplated by Congress. And where's Charter Communications today after coming out of Chapter 11? It's on the prowl, and it's about to acquire one of its major competitors, a very successful reorganization. So I want to publicly acknowledge our great sadness that you are leaving the bench, Judge Peck, although we look forward to seeing you as an ordinary mortal. And I'm going to ask this audience for a unanimous motion that in light of the losses to the Southern District of New York, that Arthur Gonzalez should immediately make an application to replace Judge Peck. Thank you.